Good afternoon. Welcome to those of you that are just joining us in this room, and welcome back to those of you who have sat in this room for one or more of our afternoon sessions. My name is Roxanne Nelson, and I am Justice of the Peace for Precinct 1 in Burnett County, and I am also a commissioner with the Judicial Commission on Mental Health. This session is called Behind the Curtain, Competency Restoration at Texas State Hospitals. This presentation will first provide a high-level overview of the individuals served at Texas State Hospitals. Our speakers will then dive into the 46B forensic admission and hospitalization process and highlight the newly developed and implemented competency restoration curriculum. They might be able to pick up where Dr. Messer left off and answer some of those particular questions that you had for him that he left unanswered. Today, we're going to be hearing from Kaylee Reza, and she is the Forensic Services Manager for the Texas Health and Human Services Commission. And joining her is Dr. Felix Torres, and he is the Chief of Forensic Medicine with the Texas Health and Human Services Commission. Please welcome them both.
Thank you very much. We will be focusing today on navigating the competency restoration process in Texas, specifically discussing inpatient care and considerations for alternative pathways. I'm Dr. Felix Torres, as mentioned. I'm a forensic, clinical, and administrative psychiatrist, the Chief of Forensic Medicine for Texas Health and Human Services, Health and Specialty Care Systems, and I'm here with the amazing Forensic Services Manager in our team, Kaylee Reza, who is a clinical social worker, and prior to joining our team, spent 5 years on the front lines working at one of our state hospitals. I'm going a little bit off script for a second. We heard a lot of lived experience earlier throughout the day, and I want to share a little bit of my lived experience and what has led me to the work that I do. Because beyond being a suit, sort of working with my team in trying to find ways to innovate and try to come up with ways in which we can better the forensic system within Texas. There's a story behind it, and that is that of my aunt and my cousin, who had mental health issues all of his life, and he cycled through the mental health system and the judicial system throughout his life in Puerto Rico. One day, after many times that he went in and out of the jails, my aunt was always his number one advocate, of course. She advocated for him to not spend that one night in jail, and found him a bed at a local hospital. And that was the night that he murdered her. And I witnessed that. I saw that happen with my mom and my sister. So the work that I do is really thinking of her memory, but also the life that was taken away from him because of the services that were not available. So I live with that every day, and this is the work that I do every day because of them. So I'm gonna let you take that first.
Okay. So we are gonna talk about, let me do the goals here. Presentation goals today are to enhance awareness of least restrictive competency restoration settings, enhance awareness of alternate pathways to treatment and case resolutions, provide considerations for when inpatient competency restoration is likely most appropriate, explain implications of an inpatient competency restoration commitment, provide an overview of the Texas State Hospital's programming, and review treatment goals within a state hospital setting related to individuals committed on a 46B commitment, and then finally review outcomes post-Texas state hospitalization.
All right, so a lot of what we will cover today is grounded on the Texas Competency Restoration Guide, which was published by HHSC in November of 2023, with the latest version being from March 2024. Now, the principles were developed through a collaborative process across multiple partners at the county, state, and national levels. It started with a SAMHSA Gain Center expert panel that was hosted in August of 2022. Then the attendees from the Texas delegation formed a steering committee to support the development of this guide. The TA Center that you've heard about throughout our previous presentation hosted 2 focus groups with subject matter experts from across the state, and then there was an additional review that was solicited through a peer review process, with the final guide being reviewed by national experts. Now, this guide includes an overview of the legal processes, competency restoration treatment, as well as different placement options. And it is available on the Texas Behavioral Health and Justice TA Center website, which you see there on the screen, the link for, and the TA Center website also has a lot of resources available. Now, you will see there the 10 guiding principles, which are intended to provide general guidance to lawyers, judges, mental health clinicians, law enforcement, families, community members, to support an effective and efficient competency restoration system. These principles are meant to be suggestive rather than prescriptive, and are to be used in the context of the services and the support available in your community. For the purpose of the presentation, I am going to be discussing and reviewing items in the yellow-colored principles, which in the interest of time, I will not be going through now, so you will get to see them, but I will discuss each as I go through them in the following slides. All right, so the epitome of the Competency Restoration Guide is the Competency Restoration Placement Decision Tree, which was developed to help judges, lawyers, and mental health clinicians identify and prioritize the various factors that can be used to determine the best available competency restoration placement for people who are incompetent to stand trial. Now, once again, the decision tree is meant to be suggestive and used in the context of the services and the support that is available in your community. It is important to know that competency restoration is not designed to be an avenue for ongoing treatment for people who have a mental illness or an intellectual or developmental disability. It is really intended only to ensure that the criminal proceedings may resume and a person may be connected to ongoing treatment over the course of their engagement in competency restoration, but connection to ongoing treatment is really not a requirement for a successful program completion. Now, the 3 principles that I want to highlight here on this slide and on the decision tree are 1, 2, and 5 from the 2 slides prior. So, number 1, access to robust, appropriate, and timely community-based services and support is essential to divert people with mental illness from the criminal justice system and to promote reentry after a period of incarceration. This is, of course, the foundation for reducing the number of people determined incompetent to stand trial and who need competency restoration. Principle number 2, people for whom the compelling interest to prosecute is low are not considered for competency restoration. People for whom the compelling interest to prosecute is high receive competency restoration services in the least restrictive setting as appropriate. And guiding principle 5, the competency restoration system emphasizes early identification and intervention, matching the services provided to the person's needs, and ensures that there is a continuity of services and support for people moving between treatment settings. All right, so looking at the tree there, you'll see that there is a line. Everything above the line is Upon suggestion of competency, anything below the line is after the competency has been determined. So above the line, you will see 1 through 4. So first of all, is there a compelling interest to prosecute? Yes or no? If no, there probably should be a consideration for an alternate disposition. If yes, the next question is there evidence of a neurocognitive disorder, a traumatic brain injury? Is there evidence of IDD? If it's a yes, maybe there should be a consideration for an alternate disposition. If no, next question, has the person been found unlikely to restore in the past, well, currently, or there's a previous history of non-restorability? Again, yes, there might be a consideration for an alternate disposition. No, the next question being, is there a history or a current, is there a current use of substances, or is the offense a substance offense? Yes, maybe there is a need for a consideration of alternate disposition. If no, then you go down to the next level. So once incompetence is determined, which is looking at below the line, then there are different levels of stratification depending on the violence and criminogenic risks, the clinical acuity, and the legal and community impact that the individual may have. Now, looking at the violence and criminogenic risk, clinicians should, the recommendation of the guide is that clinicians should use validated and reliable assessment tools to measure violence and criminogenic risk assessments to assist the court in the determination of where competency restoration should occur: community, inpatient, or carceral in jail. And the individual would then be stratified depending on where that risk assessment lies, in low versus moderate and high. We would then look at that clinical acuity, the severity of the mental health symptoms, and the level of care that would be needed to treat the individual for those symptoms. Again, stratified into low versus moderate and high. And then the last stratum being the consideration for legal severity and community impact, which may include information that was obtained from the earlier violence and criminogenic risk assessment, but also the nature of the offense, the severity of the severity of the offense, and the community impact if the person were to be released out into the community. And now, depending on where the person falls, or how the person is guided through the decision tree, is where you would find yourself at a recommendation of outpatient competency restoration, outpatient versus JBCR, jail-based, or inpatient competency restoration. All right. So on the subject of those two, outpatient competency restoration, OCR programs are programs that are there to divert people from jail and state hospital settings by providing, and this is a very, it's very short overview, by providing community-based competency restoration services, which of course include mental health and substance use treatment services, as well as competency restoration education to persons found in competency stand trial. And they are provided by a local mental health or local behavioral health authority. Now, there is, of course, a legal requirement that for the court to order a person into OCR, which would include that the person be found not a danger to others, be safely, that the person may be safely treated on an outpatient basis, and the person must be eligible for bond. And that is under the requirements of Code of Criminal Procedure 46B0711 and 46B072. Now, when considering OCR eligibility, of course, an OCR program must be available in that community. On the right, you see some of the benefits of an OCR program, minimizing the cost associated with a forensic inpatient treatment in the state hospital, making it more cost-effective. This includes, of course, the cost of associated with long-term pre-adjudication detention while awaiting inpatient treatment. But more importantly, for the individual, that's money, that's dollar signs, but more importantly for the individual, promoting recovery and community tenure by providing access to services on an outpatient basis and making that connection with the LMHA. Reducing the overall time that the individual spends in the community, in custody, and reducing the impact on the state hospital wait list by providing an alternative to that inpatient treatment. On the JBCR front, this, of course, is the competency restoration provided in the jail setting through the LMHA or the LBHA. To be eligible to participate in the JBCR program, the court must determine that the person, of course, is incompetent and is not eligible to be released on bond. And some of the benefits, somewhat similar to the OCR, supporting timely release to or timely access to competency restoration services. For those counties that have JBCR available, those beds are, or that the access to the JBCR services are definitely quicker than inpatient bed. May also increase access to community services through an earlier LMHA connection, because most of the services with JBCR JBCR services are provided by LMHAs, so that it makes the connection of the individual to the LMHA once the individual returns to the community. And then the dollar signs, minimizing the cost associated with the forensic treatment in the jail setting and the state hospitals, and reducing the impact to the forensic wait list. I am not an attorney. I may have been known to play one on TV sometimes, so I will not delve into the code, but there are several avenues to dismiss and transfer as an alternative as well. And at any time after the issue of incompetence to stand trial being raised, the court on the motion of the attorney representing the state may dismiss all charges against the defendant. Some options may be civil commitment, charges dismissed, prior to restoring or regardless of whether the individual is able to restore, and those are delineated on 46B004E and 46B151 as you see there, and you will have all these in your slides, but they're there for you to be able to view them. Now, it is important to determine which setting may be the least restrictive and most clinically appropriate environment based off of the individual's needs, as well as consideration for public safety. And some considerations for inpatient restoration are there on this slide. So, of course, as mentioned, compelling interest to prosecute, depending on the nature of the charge offense and aggravating factors, concerns and safety of the alleged victims and community, whether there is a high risk of violence and criminogenic risk, and the moderate to high clinical acuity, all these coming from that decision tree, as I was explaining earlier. So the severe psychiatric symptomatology, danger to self, others, and whether there are any refractory symptomatology, so symptoms that are not really responding to treatment and may require inpatient level of care. Now, the major principle here, going back to those 10 guiding principles, is principle number 3. Competency restoration is used only to stabilize symptoms of mental illness and provide legal education to allow for the resumption of the adjudicative process. One thing as a side note, if utilizing the decision tree, these factors may also indicate JBCR rather than inpatient, which takes us to the next slide, where I will be discussing more of a clinical picture of someone who may or may not require competency restoration. I'll turn it over to Kaylee for those case examples.
Okay, so I'm going to ask that you all engage with me a little bit here. So this is Miss Laura. Miss Laura has pending charges of assault, criminal trespass, criminal mischief, and resisting arrest. She typically lives with her daughter, who's very supportive. She has several criminal trespass charges in her history. She is a little bit symptomatic right now. She's got some auditory hallucinations, disorganized thought process, manic mood. She's eating regularly, but only getting about 3 hours of sleep per night. She's unable to stay on topic, and she's unable to rationally or logically discuss her case. She has been opined incompetent to stand trial and with the likelihood to regain trial competency in the foreseeable future. With the information we have here about Miss Laura, what might be the most appropriate competency restoration setting and why,
If all of them were available in your county.
if all were available? OCR? Okay, why do you say OCR?
So we're hearing, for the sake of those online, she is agreeable to take medications.
Nonviolent charges, I'm sorry, go ahead. Support system in the community. I guess it would depend on the details of resisting arrest. That would be important to figure out, right? Because we wouldn't want, if it was the daughter and the daughter's her support system, that might be something to investigate before making your decision. Okay. She's in jail, and I think the bottom of this says in the last 3 months that she's been in jail, she has not been physically aggressive, but she can be verbally aggressive if provoked. Well, I can too, so.
Just given the short time frames for restoration for misdemeanor charges, I would say this craves an alternative disposition, because by the time someone is assessed and gets to OCR after 3 months in jail, she's likely going to have maximized the statutory punishment range for all of these charges.
Okay, I love that thought process, yes. Yeah.
Somebody with also a dual diagnosis of an intellectual or developmental disability with an IQ of 70 or under, what is the threshold for identifying competency for somebody that may not have an IQ that would be determined as competent in the first place?
I'll let the psychiatrist answer that.
So there's no real threshold. I mean, it's going to depend on how the individual's abilities are getting in the way, or their functioning is getting in the way of their ability to understand and to be able to work with their attorney. And that's something that is going to have to be determined in the evaluation. I mean, there are some who might, in the more profound cases, of course, there's going to be, the likelihood of restorability is going to be less.
These are individuals with a 48 IQ who maybe functionally are the same as somebody who's 4 or 5, and you can treat mental health, but you can't teach out of IDD.
Yeah, I would recommend, really researching the resources available to the person, what they've utilized in the past. Do they have a DID, determination of intellectual disability? Can they have access to other services, and how can you navigate that? And then it depends on the charge. Is there, an interest to prosecute, depending on how severe the charge is? Then, despite maybe what an evaluator might say that it's not likely that they're to regain, we've seen that some courts still prefer to at least try through the competency restoration path, not agreeing or disagreeing, but just saying. So it really does depend. It's really case by case. But I'd really support researching what is available to the person.
And there's a specific methodology used, the Slater method, that is utilized in the competence restoration of individuals who have IDD. And we have recently, and Kaylee, I work with her every day, will speak a little bit about our competency restoration curriculum and some of the modifications that we have made, including a study guide for those with IDD.
I have a quick online question from Sonia Burns. Are we collecting data on how many people are applying for OCR and JBCR, and of those, how many are denied admission, and reasons why the person is denied? For example, is a person too acute for OCR or JBCR?
I think some of that information is being collected. I can't specifically speak on that. It would be more under our behavioral health services who help manage those OCR and JBCR programs, but we can find out exactly what data they do have available to share.
And someone else is asking, what happens to those who are labeled not likely to restore?
Good question, and we'll get to that a little bit later. For the interest of time, let me talk about Mr. Gregg, because we're going to follow Mr. Gregg through a hospitalization. So I'm just going to summarize Mr. Gregg. He's charged with aggravated assault with a deadly weapon. He does have a prior criminal history and a prior conviction of a different ag assault deadly weapon. He's currently homeless. He is very symptomatic. He's experiencing both auditory and visual hallucinations, as well as delusional thought content. He's not able to work with his attorney right now because he believes he has representation in London and that he does not have an attorney here. So he's opined incompetent with the likelihood to regain trial competency in the foreseeable future. And spoiler alert, he was committed to a state hospital. Let me see. So let me get to my notes. So once the determination is made that inpatient competency restoration is in fact the most appropriate setting for an individual, it's also important to understand the implications and the next steps for that individual. The average time between the arrest of an individual to the notification that HHSC has of the commitment is about 286 days for folks on the non-maximum security unit list, and about 342 days for those on the maximum security unit list. During that time, the person is likely continuing to decompensate, especially in a jail setting. And after waiting that long to get on our list, then it's another several months before the individual is actually admitted into a state hospital. So especially for my attorneys and my judges out there, really consider, when you're looking at going the 46B route, what county are you in? What services do they have? Does your county utilize court-ordered medications, which we know help improve individuals' symptoms in jail, and they may not even end up needing competency restoration? Does your county jail have mental health workers in the jail? Those are important things to consider when thinking about a 46B commitment. I'm going to breeze over this because you will get a copy of the slides, but these are all of our locations, our current and upcoming expansion projects. And then we have a nice little yellow chart to show what different services we have at different facilities. So let's get into inpatient competency restoration. The goal of inpatient competency restoration is the same for any competency restoration program. Treat and stabilize the psychiatric symptoms that interfere with the individual's trial competency. This goes back to our guiding principle number 3, that competency restoration is only used to stabilize symptoms of mental illness and provide legal education to allow for the resumption of the adjudicative process. People think of this as a way to connect a person to mental health treatment, and the reality is that competency restoration has a very narrow focus on stabilization, symptom management, and the required legal education. And though an individual that is admitted to the state hospital on a competency restoration commitment will receive a individualized treatment plan and services similar to those who are not there for competency restoration, the goals are very distinct and very different. So we like to think of inpatient competency restoration as the ICU of competency restoration. Okay. So what happens when someone is admitted to the state hospital for competency restoration? They receive medical, psychological, and psychiatric treatment for their diagnosis immediately upon admission. There's a person-centered treatment plan created with the patient and their treatment team to identify goals and action steps to work towards throughout their hospitalization. For a 46B commitment, that individual's main goal is achievement of trial competency. Now, they may have other goals in there as well, such as anger management, medication compliance, improving interpersonal skills, but the main goal and focus is going to be competency restoration. At the state hospitals, we now utilize a standardized competency restoration curriculum, which I will talk about here in a couple slides. And we also do regular assessment of trial competency done via our standardized clinically based competency screen. It's a short 6-question screen that is completed by a member of the treatment team shortly after admission, and then concurrent with the individual's treatment plan renewal, or as clinically indicated. Along the way, the patient is also receiving concurrent psychosocial rehabilitation necessary to improve or alleviate psychiatric symptoms, support their competency restoration, and minimize their deterioration in jail if they are to return to jail. A typical day for a patient might look like wake up for morning meds, have your breakfast, day room or outside time, and then the option of attending multiple different educational or rehabilitation classes, lunch, competency restoration classes, and then individual or group therapy sessions, some more free time, and then bedtime. Communication with the LMHA is a standard once per week for the first 8 weeks of admission, and then it moves to at least once per month. Attorneys should also be updated on any progress made throughout the hospitalization and are encouraged to check in on their client's progress periodically. And then in the purple, you see discharge back to jail or community. Discharge planning at the state hospital begins upon admission, and what I mean by that is the social worker and the case manager are actively checking in on the patient's benefits, income, previous housing arrangements, what worked for them, what didn't, community supports, so that in the event that they return to jail and soon plead out, or in the event that their charges do get dismissed, we have something to work off of. Really quick, let me just mention our competency restoration curriculum. It includes an 8-module training manual, as well as a patient study guide that is modeled off of the 8-module training manual. We also have a living library of educational materials, games, activities for the instructors. And then we have a Train the Trainer video series for the instructors on how to run these activities, how to run a group, and overall how to be a better instructor. And anyone is able to access our curriculum by reaching out to our team. We'll have our contact at the end, and if you would like to see those materials, you can. I mentioned our standardized clinically based competency screen, and I want to point out, thank you, that this is utilized not only in the hospitals, but also for those on our forensic wait list. We utilize it quite frequently for those on the wait list where we hear that they have been in jail for a while, they have been taking their medications, they have not had any issues, their symptoms have improved as a result of taking their medications. And so we can utilize this screen in order to see if they may be ready for an actual trial competency evaluation.
Quick plug, our patient study guide is available also in Spanish.
Yes, thank you. Yes, the training patient study guide is available in Spanish and also for those with intellectual and developmental disabilities. I want to come back to Mr. Gregg, but we have short on time. So yeah, let me talk about Mr. Gregg. So Mr. Gregg, he went through his state hospital stay. He's been there for 100 days now. He's currently compliant with his prescribed medication. His thought content is observed to be linear and logical. His speech is still a little bit rapid, but normal volume. He's no longer responding to internal stimuli. He does, however, say that he still hears voices, but they're telling him positive affirmations. He reports that his mood is good. He's attending classes regularly, follows unit rules. He continues to have delusional thought content that he owns multiple properties and that he has a lawyer in London. However, he accepts now that he also has representation in Texas for his pending legal case, and he must abide by Texas rules and statute. He is now able to discuss his legal case and understands potential consequences. He states he has spoken to his attorney and understands they are working in the best interest for him. So he was ultimately opined competent. This is one of many examples of how an individual can be deemed competent to stand trial while still exhibiting some psychiatric symptoms. Mr. Gregg still hears voices, but they are not commanding him to do anything, nor are they causing him any distress. He continues to hold fixed delusions that he owns multiple properties across the United States and still believes he has a lawyer in London. However, he has also demonstrated acceptance of his legal representation here in Texas and trusts that they are working with him for the best possible solution. And lastly, I'll just state that all of these items should be in the individual's discharge packet, whether they're returning to jail or the community. This is right out of our state hospital operating procedure of all the records that should be in the individual's discharge packet.
All right, now I'm going to turn on my Micro Machines guy. Remember that commercial where he speaks really fast? In 1 minute and 37 seconds. All right, so principle number 7, partners involved in the competency restoration process observe and promote appropriate and statutorily required timelines for tasks that fall within their respective domains. So here you see the return to court timeline. So is this timeline followed in your jurisdiction? So on our end, the provider is required to give notice and report to the court on competency no later than 15 days prior to the expiration of the competency restoration period, according to 079. After that, the individual must be returned to the court within the time that you see there. Then after that, according to 084, there are distinct amounts of time that everything must be completed by, except of course if your county has less than 1.2 million and more than 4 million population. In that case, is as soon as practicable, and there's no definition of what as soon as practicable is. But other than that, are those timelines being followed? And in the interest of time, I'm not going to go through those. But also recall that according to Code of Criminal Procedure Article 32A01C, speedy trial, it is a requirement that the criminal trial of a defendant who has been restored to competency under 46B084 shall be given preference over other matters before the court, whether civil or criminal. And some thoughts on continuity of care, which ties into Principle 6. The competency restoration system is defined by strong collaboration on the access of medications when the individual is waiting for a state hospital hospitalization and medications are being considered. You can always reach out to the LMHA if the person has had contact with the LMHA to find out what medications they've been on before. If they've been at a state hospital, you can always reach out to the state hospital, or you can reach out to our team. You have our contact information at the end to get that information. And there is, of course, Rider 35, continuity of care of individuals returning to the committing court for trial and continuation of medications. There is a pot of $500,000 per year that is not always used, and Takumi is the one that is in charge of distributing that money, and it is for the provision of up to 90 days of medications post-release, but not only medications, but also added in the last session, related lab costs, and the provider cost, so the prescriber cost, for up to 90 days for individuals who've returned back to jail after they've been restored, so for 46B individuals. And it is for the same medication that they were discharged on, according to the continuity of care plan from the state hospital. The link is there on how to access that information. And then finally, the court-ordered medications after return to jail. If anybody is on court-ordered meds at the state hospital, even if there is one day left on that court order, upon discharge and return to jail, there are 180 days. It gets automatically extended to 180 days upon return to jail if that court order was obtained under the civil prong under the Health and Safety Code 574-110.
Which most are.
Which most are. In the rare case that it was under sort of like the cell standard under Code of Criminal Procedure 46B086, that one actually there's no expiration provision under those issued by the criminal court. So if someone is under COM, you have 180 days to continue the medications and up to 90 days of free medication. And this is the final list of resources, again, available at the Texas Behavioral Health and Justice Technical Assistance Center website. And we thank you for your time.